Hello guys, welcome back to the channel. This video will cover the Indian legal system, an article of Joseph Minattur. Okay, so subscribe, like, share. Introduction: to delve among the laws of India is like bathing in the holy waters of Triveni. You know all about Triveni, that is the Sangam located in Prayagraj. The delve among the laws of India is like bathing in the holy water of Triveni. It leaves one refreshed and delighted, refreshed from the pleasant contact with almost all the legal system of the contemporary world, and delighted at the hopeful realization that here in the Indian legal system lie the seeds of a unified electric legal order which may soon grow into maturity maturity and spread its branches like a banyan tree all over South and Southeast Asia. The three men steam joined together to form an Indian legal system, that of common law in perhaps the most dominant among them. Then there is a stream of laws spring from religion. The third is that of the civil Romanist law, which energizes the system with the unruffled ethical verve and accords comeliness to its contours. Trickles of customary laws cherished by tribal societies and other ethnic communities also flow into the mainstream. Like the Saraswati near Prayag, the element of the civil law is not easily perceptible, though it is permits the entire structure. So a word of the explanation is perhaps warranted. The very idea of a code appears to have been derived from the courts of continental Europe when in 1788 a codification of Hindu law on the context and succession was proposed by the Sir William Jones to Lord Cornwallis. It was conceived to be on the model of the inestimable, inestimable Pandects of Justinian. On 18 May 1783, a regulation for the forming into a regulation code or regulation that may be enacted for the internal government of British territories in Bengal was passed by the Governor General and Council. Some 8 years earlier, in 1775, Warren Hastings had a code of Janchu law or ordination of Pandits, prepared and translated by the head a judge of Supreme Court at Calcutta. The same year, Bentham offered to act as a sort of Indian Solon and thought of the constructing an Indian constitutional code. James Mill, one of his disciples at the India House, thought that his draught of a new plan for the France was applicable to India. Speaking on the Charter Bill of 1833, Macaulay said, "I believe that no country ever stood so much in need of a code of laws as India, and I believe also that never was a country in which the want might so easily be supplied." Section 53 of Charter Act 1853 declared that it was expedient that such laws as may be applicable in the common to all classes of the inhabitants due regards being had to the rights, feeling, and peculiar usage of the people should be enacted all the laws and custom having the force of law should be ascertained and consolidated and as occasion may be required amended. The first law commission immediately after the appointment in 1833 with Lord Macaulay as its president took up the task of codification. Under the Macaulay's personal direction, it prepared its first draft of Indian Penal Code and submitted it to the Governor General in the Council on the 14 October 1837. When there were complaints that the progress of the Commission's work was unsatisfactory, Macaulay compared its progress with that the authors of the French codes. He pointed out that though the French criminal code was begun in March 1801, the code of the criminal procedure was not completed till 1810 1810 1810. It is also interesting to find half of the last century were on the same branches of law as were the French codes enacts earlier. Neither in India nor in France was enacted a code on the law of evil wrong. It is true that there was no comprehensive enactment on torts in England, but then there were no comprehensive enactments in England on any of the subjects covered by the Indian courts. It is not only in the cherishing the idea of codification that the British Indian authorities, executive as well as legislative body, appear to have been indebted to continental courts. As early as 1686, in a letter sent to Bombay, the direction of the India Company had expressed the view that you are to govern our people there being subject to us under His Majesty by the law, martial and civil law, which is only proper to India. The first law commission which drafted the Indian Penal Code acknowledged its indebtedness to French People Code. In a letter of 2nd May 1837 addressed to the Governor General, the Commission stated that it derived much valuable assistance from the French Code and from the decision of the French Court of Justice on the question touching the construction of the code. It derived assistance still more valuable from the code of the Louisiana prepared by the late Mr. Livingstone. The second law commission, which sat in London from the 1853 to 1856, expressed its view that what India wants a body of substantive civil law. It's in the preparing which the law of the English should be used as basis. It however emphasized that the such body of law ought to be prepared with a constant regards to the conditions and the institutions of India and the character, religious and usage of the people. It also stated that in the social condition existing in India, it was necessary to allow the certain general classes of persons to have a special laws recognized and enforced by our courts of justice, with respect of certain kinds of transactions among themselves. The Commission gave final shape of Macaulay's Penal Code. It also prepared drafts of the Code of Civil Procedure and Code of Criminal Procedure, incorporating into them materials left by the first law commission. The Legislative Council adopted the Code of the Civil Procedure in 1859, the Penal Code in 1860, and the Code of Criminal Procedure in 1861. Okay. The third law commission appointed in 1861 was enjoined the prepare of India a body of substantive law in the preparing which is a law of England should be used as a basis. The fourth law commission expressed a similar view when they recommended in 1879 that the English law should be made the basis in the great measure of the our future courts. But its material should be recast rather than the adopted without the modification. It however added that in the recasting those materials due regards should be had to native habits and modes of thought. The influence of Scott and their law on the framing and adopting of the early British India codes and other enactments deserves to be mentioned. For a number of Scots in the 19th century, their prospects were not only along the highway to London but from there across the high seas to India port. Macaulay himself was of Scottish descent, even when Scott were the member of the English bar. They were imbued with the concepts derived from the civil law system. In the same way, they would prefer to preserve Scots law unsullied by the English nations of regal rule. They were inclined to keep in Indian law unsullied by the intrusion and the erosion to the English rules of law, tended to give due regard to native habits and modes of thought. We shall refer to few instances where the influence of the civil law is clearly discernible. Section 11 of Indian Evidence Act adopted in 1872 could not have been enacted in a fit of the absence of mindedness. The section which lays down the guidelines to the determine relevance in the admissibility of evidence act is a clear and presumably a deliberate departure from the English rule and bring the Indian law in the respect very relevant and fair. Another provision which is of interest is this regard. In the section 165 of the Act, commenting on it, as Stephen has said, Section 165 is intended to norm the judge with the most extensive power possible for the purpose of getting at the truth. The effect of this section is that in order to get the bottom of the matter before it, the court will be able to look at and inquire into every fact whatever. The Indian judge appears to be invested with ample powers under the Act to get at the truth and form his own conviction at time. It is not unfamiliar learning that the Farmers of Indian Contact Act adopted several provisions of the draft New York Civil Code. The Contact Act, which does not purport to be a complete code, only defines and amends the certain parts of the law of contact, so that a rule of the Hindu law of the contact like Dhamdupat, the rule of the Hindu law contact like Damdupat is not abrogated. The rule stipulates that interest of the Hindu law of contract like Dhamdupat interest exceeding that the amount of principal cannot be recovered at any time. It is still in force in some parts of India. The reason for not interfering with a rule like this must have been the sense of fairness cherished by the farmers of the act, though no such rule existed in the English law. In the law of contract, consideration plays a significant role in India as in England, but the words of Section 25 of Indian Contract Act, which accords validity to a registered agreement, even though without the consideration appear to reflect a concept of cause in the French law. In this brief introduction, it is not intended to indicate all the departure from the English law in the Indian statutes. It may be, however, it be emphasized that when such a departure were made, the legislature were generally induced to do so on the consideration of what they thought suited Indian condition or consideration of equity. It is generally assumed that India is a common law country. This assumption may have been justified to a certain extent. It implied to British India. It is true that many of the concepts and the most of the judicial techniques are from common law, are of common law origin, but there is more than a sprinkling of other concepts and teaching techniques which cannot be overlooked. Indian courts or judicial procedure owe a great deal to procedure in England. But with the introduction of the Nyaya Panchayat village tribunals, which are indigenous in the origin of English procedure, has been virtually replaced at the grassroots level. The functioning of Nyaya Panchayat may not be as widespread as is desired. The fact, however, remains that at present there is a less formal procedure than the one followed until recent year. There is also general dissatisfaction, if not hostility to the complex, protracted procedure derived from the common law system, with the reign of dharma, which may be equated with the equity, while it comprises the concept of law unopposed to justice. There was no need to India to think of the separate branch of law known as the equity detached from common law. We have already adverted to certain departure from the English law even when rules of English law were believed to have been codified for the benefit of Indian people. Neither the expression justice and right in the character of 1726 1726 nor the phrase equity and nor conscience or justice. Equity and good conscience in several regulations and act could have meant principles of English law. The Judicial Committee of the Privy Council was careful in its use of words when it pointed out that equity and good conscience had been generally interpreted to mean rules of English law if found applicable to Indian society and the circumstances. It has been observed that from the 1880 or thereabout to present day, The formula has meant consultations of various systems of law according to the context. At the present of the Supreme Court of India is inclined to think that the phrase has given a connotations consonant with the Indian condition. In the early 90th, 60th, 90, in the early 1960s, a number of territories where a civil law prevailed became a part of the Indian Union. In the Indian territory of Goa, Daman and Diu, Portuguese civil law was in force, even after the extension of several Indian enactments to the territory. It is generally to provision of the Portuguese Civil Code, which applies to the people of this territory in matters of personal law. In the former French settlement of Pondicherry, Karaikal, Mahe, and Yemen. Pondicherry's three districts, Karaikal, Mahe, and Yemen, which when ceded were formed into the Union Territory, now the known as the Pondicherry. There are Indian citizens who are gone uh, in matters of personal law by the provision of French Civil Code as they existed at the time of the accession. There are also the other renouncants, renouncants who are French sitting living in the Pondicherry, to whom provisions of the French Civil Code relative to the personal law will apply with all the subsequent amendments in these circumstances. The elements of the civil law in the fabric of Indian law cannot be brushed aside as the negligible, and this element affects domestic relative relations which are on negligible part of a citizen's life. The customary laws of various tribal communities and other ethnic groups are form part of law administered in India. To cite one instance, matrilini among the Mappila Muslim of Kerala, though not favored by the tenets of Islam, is permitted to play a decisive role in the role of succession applicable to them. In the light of the presence and prevalence of French and Portuguese laws, customary law of the various ethnic groups, and laws based on the religion of the several communities, the the introduction of the indigenous judicial procedure in village tribunal, and several other factors, one cannot possibly close one's eye and regards the Indian legal system as belonging to the common law family. It would more justified to regards it as a mixed system. If the Indonesian law with its mixture of customary law based on the religion could be regarded as the mixed system, there is no reason why India law should not be regarded. Though the provisions of the French and the Portuguese civil codes relative to the domestic relations are in the operation in the certain religions only, laws grounded in religions or the customs are flawed. All over the country, the mosaic of Indian law may have a large number of common law pieces, but marble quarried marble quarried from the France and the Portugals, gold leaves brought from the Arabia, and cluster of the precious stones gleaned from the Indian fields do deserve to be discarded. When India adopts a civil code under the direction of the constitution is likely to be eclectic in nature. It may have in it a harmonious admixture of various laws based on the religion and customary laws, as well as a provision derived from the vast Western codes and the English common law, owing to its eclectic character and especially because it would attempt to harmonize provisions of personal laws derived from religion prevalent in the region. The civil code uh, may be found worthy of emulation is South and the Southeast Asia. It may thus pave the way of the unification of law, though the perhaps limited geographically in extent. If in ancient days Indian culture was permitted without any hitch or demur to permeate social and the political institutions and life in the general in this region. There is no reason why Indian legal culture cannot play a similar role in the near future as well as. The Indian Prime Minister recently expressed his hope that during the next 9 years, India would achieve significant progress in every field and would provide guidance and inspiration to other countries. He also stressed that India's influence had been increasing in Southeast Asia and West Asia, even when one is not sure whether the mention of 9 years has any special significance. One can hopefully assume that the Indian Civil Code is adopted soon. It may tend to guide and inspire the legislature in the neighboring states. What the Napoleon, what the Napoleonic Code has done for the continental Europe, the Americas, and parts of Asia and Africa as well. A well framed Indian civil code may easily do for South and South Asia. So, guys, in this video, we'll just cover an article of Joseph Minattur regarding the Indian legal system. Next, we will cover the next series of the jurisprudence case material about the hierarchy of courts. Okay, so okay, thank you so much for watching this video.